All right. Hello, hello. Good afternoon or good morning, wherever you're tuning in from. Thank you for attending this live webinar being hosted by Texas Legal. Hey, my name is John Nwosu. I'm an attorney in Dallas, Texas. I do family law exclusively. I've been doing that for over 13 years now. Okay. And then today the webinar will be on grandparents' custodial rights in the state of Texas. Okay, information provided today will be very specific to the state of Texas. So if you are tuning in from other jurisdictions or other states, just bear that in mind that the information that we're providing today applies to this exclusively to the state of Texas. Okay. Like I said, this webinar is being brought to you by Texas Legal. Some of you on here probably got this heard about this through either you're a subscriber to Texas Legal, you're a Texas Legal subscriber, or you find it on their social media or YouTube channel. If you don't know about Texas Legal is a statewide nonprofit legal benefit plan that was formed by the State Bar of Texas to better meet the legal needs of Texans. Texas Legal provides member access to over 400 network attorneys, and the Texas Legal offers various legal insurance options. Contact information for Texas Legal will be in the comments and description box of this webinar. Please contact Texas Legal for more information on benefit plans that they do offer. Okay, and then once again, thank you, Texas Legal, for helping make high level legal services at least affordable to Texans. All right, before we start, I have to issue a disclaimer. The information that will be provided in this webinar does not and is not intended to constitute legal advice. Instead, all information, content, or material available on this webinar are for general information purposes only. The information in this webinar shall not be construed as an offer to represent you, nor is it intended to create, nor shall the receipt of such information constitute an attorney-client relationship. So every information I'm going to provide today will be on a very high level. So if you really have, every situation is different, everybody's situation is different. So if you have a unique situation, if you have your situation and if you need to discuss, you need to probably find an attorney or consult an attorney to discuss your unique situation. Okay, that being said, let's dive in. All right, today, this will be the roadmap for those watching. This will be the roadmap of how my presentation will go. This will help also keep me, organized, and also keep you to be able to know what is coming next. I will not really, tell you when I say we're, but today I will focus on the grandparents' custodial rights to their grandchildren in the state of Texas. When should a grandparent consider obtaining legal custody in the state of Texas? What to expect, when the grandparent files a lawsuit in court and trying to obtain custody. And also, I will provide you some takeaways at the end of the webinar. Also, at the conclusion of the presentation, I may be able to take some questions. The questions will be form of like providing a general answer. I cannot answer very specific questions. So if you have any questions from this presentation, do type it on the comments so I may be able to address it and get to your question at the end of the close of my presentation. Okay. All right. Let's start. The most recent census report tells us that in the United States alone, over 1.5 million children live exclusively with their grandparents. Okay, that's one of the important why Texas Legal wanted to bring this topic and address this topic to you, because a lot of these grandparents are raising their grandchildren in the United States, but a lot of them do not have any legal custodial rights. So we will go overview of the grandparents' custodial rights and also their rights to possession and access, which we call visitation rights, to their grandchildren in Texas. Okay. All right. So in the state of Texas, a grandparent, can petition to have legal custody of his or her grandchild. Okay. And grandparents could intervene in a custody proceeding over their grandchild. So let's say if there is a custody, proceeding going on between the parents or another relative, a grandparent can actually intervene in that lawsuit and enter that lawsuit to seek custody, to seek to be appointed as a conservator to get custodial rights over their grandchild. Also, even if there is no case ongoing, if there is already a custody order where the custodial rights were given to the parents of the child or another entity or another relative, grandparent can actually file and ask the court to modify that existing court order and give them some kind of custodial right over their grandparent. Also, the fourth one, grandparents also, they don't always have to be asking for custodial rights. They can actually file a suit asking the court to award them, what is called a reasonable possession and access to their grandchildren under the right fast. So, they can ask the court to give them some reasonable access and possession to their grandchild, but the fast has to be right. We will discuss that in detail when we get to that. Okay. These, you don't have to know this statute. I just put it there. And because to file any suit in a court, you have to have some kind of standing. Standing means you have to have a right to be able to bring that lawsuit. In the state of Texas, under the Texas Family Code, these are the statutes where grandparents may be able to derive a right, a standing to be able to file a lawsuit on their own in a court, in a family court or in a district court or county court, depending on where you live in Texas, and seek either custody over their grandchild or ask for reasonable access, possession and access to their grandchild. Okay, so these are different statutes that give you that give the grandparents those rights. Okay, all right. So here we talk about grandparents and SAPCR proceedings. SAPCR in Texas, it stands for Suit Affecting Parent-Child Relationships. So every suit in Texas that has to do with conservatorship, it could either be a paternity suit if the child's paternity has not been determined in court, but generally they will all fall under the Suit Affecting Parent-Child Relationship. That's what that SAPCR stands for. Okay. And then the first one you see on there says, has the child lived with you for over 6 months? Okay, if your grandchild has lived with you exclusively, consecutively, I would say, for 6 months, and you could file, you could petition a court so you can get a custodial right over your grandchild. Also, even if the child has been taken away from you, so an example where maybe your child, which is the parent of the child, left the child with you for 6 months straight, and then maybe on the 7th month they came, or your child came, the parent of the child came and took the child away from you. As long as it has not been 90 days since the child left your possession, you can file, petition a court to get custodial rights. Okay. Also, if both parents of the child are deceased, a grandparent may petition a court to get custodial right over their grandchild. Also, like I talked earlier, the suit that a grandparent filed doesn't necessarily have to be to get custodial right or to be appointed what is called a conservatorship of the child. They could just file a suit on their own to get a suit for possession and access, to their grandchild. But this has to come with an affidavit, and the affidavit they have to, swear under oath that denying them access to their grandchild will cause significant impairment to the child's physical health and emotional well-being. So those things has to be there, and the court has to find that appointing the non-parent as giving them access will be in the best interest of the child. The non-parent in this case being, the grandparent. Okay. Also, of course, if the parents of the child, agree for the child to live with you, they can always, you can always file for custodial rights as well. Okay. Moving on to the next slide. Okay. Here we have, it's called reasonable possession and access to your grandchild. Okay, and here I think I alluded to this earlier, where a grandparent can file and ask for reasonable possession and access to their grandchild, and the grandparent has to show, if also these things has to be applicable here. If an example is, if one of, let's say you have a grandchild, but you are the parent of that child, which is your child, the grandparent child, if the right has been terminated, then that grandparent has no right at all to either seek possession and access or custodial rights to their grandchild. It makes sense, right? Because if your child, who is the parent of the child, if his right has been terminated by a court, then that line is foreclosed for that child. If the child has been adopted, of course, you'll be the adoptive family's grandparent that may have right to seek access, but the biological parent's right, that the right has been terminated, has no more right, including the grandparents or relative of that parent that has their right terminated. Okay. Also, the grandparent requesting access, like I mentioned earlier, has to show that a denial of access to the grandchild would significantly impair the child's physical health or emotional well-being. It has to be able to show this. Okay. And then the grandparent to the child is a grandparent of a child, and that parent of the child has either been in prison for 3 months prior to the filing of the lawsuit. In real life, this thing actually happens more often than not. The parents are living together. Maybe one parent gets sent to prison because of some criminal offense, and this grandchild has always had relationship, with the grandparent. They're bonded together. They build, the child has some connection to their grandparent. In a case where maybe the other parent, the one that is not in prison, may not so much have a good relationship with this their significant other's grandparents, they might start denying, them access. So a grandparent petitions here, they have to show us, that denying them access will significantly impair the child's physical health or emotional well-being. So they have to show that they've had relationship with that child with some evidence. Also, if your grandparent and your child have a child, the person has been found to be incompetent, you can also petition to have some reasonable access to your grandchild. Also, if your child, who is the parent of the child, is deceased, you do have a right to file in court and still show that denying you access will significantly impair the child's physical health and emotional well-being. I hope this makes sense. It's just the fact that your child is sent to prison doesn't just give you the right to come and file, or the fact that your child is dead. You still have to show the court that denying you access to your grandchild will significantly impair the child's physical health or emotional well-being. Okay, so folks out there, do maintain relationship with your grandchild. Hopefully it doesn't get to that, but you have to maintain some kind of continuous relationship to your grandchild, so that in case you ever have to go to court, you can show that you and your grandchild has bonded, and it will affect them if you were denied access to them. Okay. All right. This is this is a big hump this is a big log in this road, and it's not always easy. When you file this lawsuit, expect to be challenged. Expect to be challenged by the child's, by the parents of the child. So what do you expect? What to expect when you file a lawsuit? Okay. All right. The Supreme Court of the United States has told us in a case, Nwosu v. Granville, that was decided in the year 2000, it told us that parental right is the most fundamental right. It created what is called the fit parent standard. Okay. And what does this actually mean? It just means that a fit parent, acts in their children's best interest. So this is a case where the grandparent was trying to get some kind of custodial right over their grandchild, and the Supreme Court said, wait, before you take away, or you take away this parental right of these parents, you have to show, to their right to be able to parent their children the way they seem fit. You have to show that they are not fit parents. Okay. And then in response to that case from Supreme Court, the Texas legislature adopted the significant impairment standard. You can find this in Texas Family Code, section 102.004A, subsection A, subsection 1. Also, just recently in the Texas Supreme Court has to deal with a case that has to do with a modification. This was in Red CJC. In that case, the Texas Supreme Court reaffirmed the right of fit parents to make decisions regarding their children free of governmental interference. Okay, what does this mean? Of course, when you go to court, you're trying to use the power of government, the court, to take away a parent right to rear their children. So the Texas Supreme Court do reaffirm that the right of the fit parents to make decisions regarding their children is supreme. So you have to overcome this to be able to get either some kind of position and access to your grandchildren, or to be able to get custody over your grandchildren. Okay. And I talked about it a little bit, this parental presumption. What does that actually mean? Okay. Like I mentioned earlier in the previous slide, the presumption is that the fit parent acts in the best interest of their children. It's a concept that anyone that have children, could relate to, right? Because you expected that any parent should be able to care and provide shelter and protect their children. So this was the same case from the Supreme Court. This is where this standard was established. And also, in the Texas Family Code, it is said that parents must be appointed joint managing conservator of their children. Okay, so this is that is where it starts. You have to start with that person. Parents must be appointed the joint managing conservator, unless if there is a history of family violence, or if the court finds that appointment of parent or parents will not be in the best interest of the child, because that appointment will once again significantly impair the child's physical health or emotional well-being. So this is when the court may then not appoint the parent or a parent as a managing conservator, joint managing conservator or conservator of the child. Okay. The presumption to overcome. So we've been talking about this. So you, the grandparent that is trying to seek either custodial right over your grandparent or trying to get some kind of visitation right, you have to overcome the presumption that a fit parent acts in the child's best interest. So you have to show the court that the parents are not fit, and they're not, either by their action or inaction, that they are not acting in the child's best interest. So you have to address this in court by showing some supporting evidence, not just saying it. You have to go to court and be ready to provide evidence of this. Okay, overcoming the parental presumption. Okay, in Texas, if there is a history of family violence, it removes this presumption. Okay, so what does this mean? So if there has been a history of family violence between the parents, then the presumption that they are the fit parent, of course, it will be the offending parent, not the victim parent. It removes that presumption that that parent is fit. Again, it's an easy concept to understand, right? If I think we all at least agree to some extent that if someone is actually committing family violence to a member of their household, that they may not be a fit parent to raise their children. Also, another thing that we see often in practice is where if a parent has voluntarily relinquished the actual care, control, and possession of the child to a non-parent, maybe like the grandparent, for a period of 1 year or more, so if, the parent of the child has left the child with you for over a year or more, it kind of makes sense to go and argue that if you can leave your child for 1 year or more with the grandparent, it makes sense, it removes that presumption that you're a fit parent. I don't think any fit parent will leave their child with someone for over a year. And also, like I mentioned earlier in that 6 months portion, if let's say your child, the parent of the child leaves the child with you for over a year, and then maybe in the 13th month or 14th month they appear and they take away the child, it does happen more often than not. You can bring a suit within 90 days of them removing the child. So it doesn't have to be, you don't have to bring the suit right away, but after 90 days, you have to that presumption, is reestablished. So you have to bring that lawsuit for custodial rights within 90 days of the child being removed from you. Of course, the child doesn't have to be removed from you for you to be able to seek custodial right. If the child is still living with you, you can still petition the court without having the child being removed before you seek custody. Okay? All right, so this brings us to the end of the presentation. Like I mentioned earlier, this is a very high-level overview of grandparent custodial rights. If you have a unique situation, if you have things, you should consult a lawyer and try to run your unique situation and discuss, strategies with a lawyer that you consult to just be able to answer your specific questions related to you, because everyone have their situations are different. Okay. One of the takeaways I want people, because you see a lot of times, most of the time when you see grandparents walk into our office here, is when either the child has been taken away from them and then they waited for a long time and they show up, or when they needed some kind of legal document showing that at least they have legal custody over the child. I try to tell you, don't have to wait. Okay. You can get legal custody of your grandchild if the facts are right. So don't wait until you need a court order to do so, because at that time, sometimes it may be too late. Okay. And then do maintain continuous contact with your grandchild in case, I'm not saying that it's going to happen in your case, but I did give some example where, in case if the parent of the child passes away and the other living parents start denying you access to your grandchild, you can go to court to seek possession and access to the child. Then if you show the court that you've bonded with this child and the denial of access will significantly impair the child's physical health, emotional well-being, the court will consider that. So do maintain some contact, with your grandchild. Also, people, a lot of grandparents don't know this. Yes, if you get custody over your grandchild, you can ask the court to order the parents of the child to pay you child support, because you're supporting their child. So they can pay you child support. And also, if you're providing health insurance to this your grandchild, the court can order them to reimburse you for the cost of providing health insurance to their grandchild. So it is possible. Okay. These are the helpful websites, and this is the first one is Texas Department of Family and Protective Services, what we call DPS in the state of Texas. There is a section there for seniors and grandparents seeking custody. You can go online and check that out. There's also an organization called Elder Options of Texas. They do have some information about grandparents and raising their grandchild. You see also Texas Grandparents Raising Grandchildren. You'll find that in the website on number 3. Also, the number 4 helpful website I have on there is Texas Legal, who is bringing this webinar here to you. You can also go to their website. One of the things you find being a subscriber, they give you access to high-level legal representation at an affordable cost. Everybody knows that hiring a lawyer is one of the most expensive endeavors you can undertake. So you can check them out and see what options they may offer you for legal insurance plans. Okay. And this is me. This is my information. I believe is also in the comment. And if you need to find me, I'm here in Dallas County. I'm in Dallas, North Dallas, on Coit. And I have a website that you can pretty much find me on any of the social media platforms, Instagram, Facebook, YouTube. I'm on there. Okay. And thank you for allowing me to present this to you and then I will look to see whether there is any questions or comments, and then I may be able to answer them if it's possible. If it's not something I can answer in a public forum like this, I will also address that. All right, let me see here the questions that we have. All right, give me a minute. Well, let me look at this question. All right. Darren, I see a question he asked. He said, what about registering a previous custody agreement that was part of an MSA from California, registered in Texas? All right. I will try to answer this question as much as, because when you say an MSA, it seems like you're not talking about a court order. So if there is a court order from another state, the state of Texas has to give it full faith and credit. You know, if you have an MSA that is not a court order, so because a court order, there's a provision in the statute in Texas that will give the full faith and credit, accord a full faith and credit to a court order from California. But there is no provision for you to be able to register an MSA. Okay. And, you may want to also sit down, have a consultation with an attorney to go through this MSA that you have in California to see how you could maybe use that as an avenue, to try to file a petition here in Texas. Yes, Darren, you have two questions here. The second one is about requesting modification. Anyone can request it. I think I pointed out he can request a modification of an existing court order. He can actually intervene in an ongoing custody case concerning your grandchild in Texas. And like I pointed out, definitely he can ask for child support, just like if their income changes, he can also ask the court for an increase if there's already a child support. He can do that. Okay. And Mr. Jerry asked whether the presentation will be available for download. I believe it will be available on the Texas Legal YouTube channel. So if you are watching this through their YouTube channel, you can click subscribe, and then you should be able to access this anytime you want by going to their channel. Sandra, I see your question. Your question is not a question I can really answer in a public forum. This is a public forum, so you will have to really have a sit down with an attorney to go through, what the facts of your case, your unique situation, to see whether you may be able to meet the standard, to be able to either get custody or get possession of your child. Okay. All right. And then that'll be, I think that's it. All right. Thank you, everyone, for attending this webinar. Okay. And then would also thank you, Texas Legal, for inviting me to bring this important topic to you all. Okay. And then you all have a wonderful, enjoy the rest of your afternoon if you're in Texas. And bye.